All right, it's becoming a little bit of a Wednesday tradition here. We bring in some of our favorites here from the legal world, and we pose some of the questions that are both on the front of certainly national consciousness, but also some that aren't. But trust me, you'll be talking about it, and our first topic is one of those. Let's bring in the panel first. So, Jim Kasoris, he is a criminal defense attorney in Manhattan, lectures at New York Law School, visiting professor at the University of Birmingham in England. I always want to say that with an accent. Doug Von Oist, founding partner of Karsten Von Oist, focusing on corporate misconduct, selected by the legal 500.
Business is good.
Yes, absolutely. Most influential trial lawyers in the nation. Back from where?
Syracuse.
Oh, lucky you. And Mayo Bartlett, he attorney, of course, and former chief of the Bias Crimes Unit at Westchester County DA's office. And as we've mentioned before, with a couple of very high-profile cases that he's working on as we speak. And Mark Furnish, professor of Brooklyn Law, and an attorney who, can any of you say this, has argued before the Supreme Court.
And lived to tell, yeah.
Well, yes, and lived to tell that. Okay. Supreme Court has got a very interesting case in front of them. They're going to have to decide whether or not police may constitutionally search the contents of an arrested suspect's cell phone without a warrant. Now remember, he hasn't had his day in court. He's just been arrested. Now, Mark, let's lay out a scenario. God forbid I am doing something allegedly I shouldn't be doing. They say to me, hand over your phone. And I got to produce my phone, and then they can, if they want to, go through my recent calls, my contacts, and I can't say no?
Well, it's not so much the seizure or the taking of the phone that's an issue, but what happens afterward. You know, they can take the phone, but can they go through it without getting a warrant? That's the question. And the argument is that the phone is vastly different from any other kind of container that you might have on your person. You know, it's not disputed that if you have a pack of matches in your pocket and you're being arrested, they can search that, you know, to see if it constitutes evidence of a crime, or God forbid you might be holding something dangerous in there. But everyone can sense intuitively that a matchbook is a little different from a smartphone. You've got your whole life in that smartphone, so it's really more like a house than a matchbook.
Well, let me ask you, if I get into a bar fight, I get arrested, and they take my car keys off me if I have it on my person, are they allowed to go into my car and search my car?
No, they'd have to get a warrant for that. But a car is a different kettle of fish because it's mobile. So there's a whole different set of Fourth Amendment standards that apply to cars. This is really.
But if the phone's not used in the commission of a crime, then what's the argument that it's fair game?
It might be used in the commission of a crime. If you're a drug dealer and you're arrested with a cell phone on your person, it's highly likely that you'll find evidence of crime in the cell phone, maybe contacts of clients, records, ledgers, and stuff like that. And on that rationale, it should be very easy for them to go get a warrant after they seize it. So that's really the question.
It's interesting where this thing could go, and it's all just technology, right? I mean, we keep coming up to these questions that the law hasn't caught up.
Seems to me like it's a way of policemen to not do their job, really, more than anything else. I mean, because you're not saying that the evidence is going to go away. You're basically saying you have to take another step to get a judge to give you the warrant.
Well, some judges say the evidence will go away. One of our most prominent jurists, Richard Posner in the Seventh Circuit in Chicago, says people are technologically savvy enough that if the police hold the phone while waiting to get a warrant, that one of the arrestees' co-conspirators could wipe the phone.
And that brings up an issue that really you'll be talking about, hopefully with us, in a year from now. And that is the extent to which technology is going to eviscerate our Fourth Amendment privilege. So if you can wipe a phone clean, you can wipe a computer clean, you can wipe out all of these devices, does that therefore mean that because evidence can be destroyed, the Fourth Amendment doesn't apply? They can come into your house and arrest you and take your computer on the argument that a co-conspirator can wipe it clean? Technology is getting more and more and more sophisticated, and as that happens, there is the possibility that these arguments are going to be made. Right now, I don't think anybody can wipe a phone clean completely.
And everything's backed into the cloud.
That's
we were
right.
talking
So
about off camera. Yeah.
I don't know where that argument goes, but and so really all it's about is get a warrant. Get a warrant.
Well, it's about collecting data, and really what you're doing is once you get that phone, you know, no password's going to stop a forensic unit from a prosecutor's office from going thoroughly through that phone. They're going to have all of your data, all of your passwords, all of your contacts as anybody that you're dealing with, and they may not use it. They may not even let you know that they have it, but it's there. So now they can use that to build other cases. They can use that to your disadvantage, and you won't even be aware of it because you're going to trial assuming that whatever communications you've had with your attorney are privileged, but yet they may even have the emails between you and your attorney on that phone. There's nothing at all on a phone in particular that is so exigent, that you need to take it right now without a warrant.
But it just strikes me that I haven't had my day in court yet. I haven't been charged yet. You just pulled me over because I'm speeding, you allege I'm speeding at a high rate. You take my phone? I don't know. It seems like this is a real slippery slope here if we're not careful. Am I making more out of this than it could be?
You're not. You have an expectation of it's what the Fourth Amendment is about. You have an expectation of privacy.
We keep coming back to this debate, don't we? As it relates to surveillance, as it relates to...
You have an amendment that was written in 1789, and the kind of technology today was not even a glimmer, obviously, in the framers' eyes back then, as prescient as they were. But throughout the history of this country, the Fourth Amendment has had to be adopted to emerging technologies. And as Jim said, what we're doing now is grappling with how to apply, conventional bricks and mortar Fourth Amendment doctrine to a novel kind of technology.
Mark, I have to ask you this. Last year, in Jones versus the United States, the Supreme Court held that when the police go to your car on a public street and put a GPS device on it, it's in public, and then monitor your movements, that is an impermissible search under the circumstances of that case. So how then is it permissible to take a phone that you have in the privacy of your vehicle on your seat and just open it because you've been stopped for speeding or a suspended license, and look at the photographs you have with your closest relatives, with the private matters of your life, which we store.
These cases are going to answer a lot of the questions that were left open in Jones, because as you know, they took the narrowest possible rationale to dispose of that case, which is that the police officers trespassed onto the guy's driveway by attaching the GPS device to the undercarriage of the car, and they didn't reach the question whether he had a reasonable expectation of privacy in the car and in his movements for the 30-day period under which he was surveilled. This is raising squarely the issue of the reasonable expectation of privacy in the contents of the phone, and whether that kind of expectation could be overcome by the exigencies of the moment, namely preserving evidence and minimizing some putative threat to police safety.
But they did hearken back to law from the 1700s in deciding Jones.
And
so
that was
they still,
vintage Scalia to do that.
That's right.
Well, the
they
next
still
step
go
too
back
is
there.
that you go into someone's office, you take their computers. You don't bother to get a warrant anymore. Just take the computer because it can be wiped clean. So if that's the case, you should have your warrant when you're going to get it. If you know this in advance.
But you can't. Because a warrant requires that you have probable cause to believe that there's contraband within that item, and you don't. Because you've just stopped poor Rich over here for a suspended license
So it's a
and
fishing
nothing more.
expedition.
Well, that's it. The situation in which police will be hampered if they have to get a warrant is when they want to fish for something they don't already have. When they already have some hard evidence or solid suspicion that the phone is going to house evidence of crime by virtue of the nature of the crime, drug dealing, child pornography, whatever, getting a warrant is a formality and it's no problem. When they want to fish around, they're going to have a bigger problem.
Now, this question, you raised this before, and I think anyone who served on jury duty or even watched Law & Order, the expectation is there's a presumption of innocence when the defendant's sitting there. Jurors are often instructed about it, but rarely are they given, according to many, adequate instructions about what the prosecutor's burden really is when it comes to proving guilt, and this is the important thing, beyond a reasonable doubt. I think the general public says, of course they do. Everybody knows what the line is. But you think that's not true, and you don't even think it's done right from the instruction phase.
It's not true at all, and a part of it goes back to technology and the fact that today you have so many shows that deal with the criminal justice system. People watch Cops, they watch Law & Order, they watch all of these different shows, and they listen to the judge. The judge gives a very, very brief instruction with respect to the law. The judge says, okay, now this person's innocent until proven guilty, everyone nods. Half the people aren't necessarily even paying attention as they're nodding. And then if I happen to say, well, does anyone think my client must have done something wrong because he's lucky enough to sit next to me today? Okay. And of course, all the hands go up. And when the hands go up, the judges say, we're never going to get a jury. You're sabotaging this process. I said, well, wait a minute. I don't think they've really thought it through. And even within the law itself, there's no real clear definition in terms of what we're looking at when we talk about beyond a reasonable doubt. What's the percentage? Is it 90%? Is it 80%? There is no real percentage, so we're sort of asking them to figure it out as they go along.
And it's funny, if you ask the general public, who's the deck stacked more in favor of? They say, oh, the defense, you know, because all they got to do is get one guy on the jury here to see it their way. I guarantee you, if we ever did a poll, and maybe you guys have even seen this from the ABA, it's that they're like, you know, prosecution, they're already coming up with 2 strikes against them. But reality is a little different, huh?
But you know, there's also another thing. If the client sits there and if the defense is quiet, reasonable doubt there is an issue, a lawyer can really hit it home, we don't have to say anything, it's their burden. But if you actually go out and try to put on a case, it all goes out the window, I think, at that point. It's whose story do you believe at that point? You know, do I believe the prosecutor or the defense? And it's not really beyond a reasonable doubt.
No. And sometimes they want to hear from you. They may hold it against you if you don't testify. They'll say, well, why didn't he speak up?
But Mayo, we all know that in life, when somebody's accused of something, you expect them to stand up, and so you know, and to you know, tell their story, and so you know, you can't blame jurors. And after 28 years, I don't think this is naive. I've tried a lot of cases. The bottom line is, I think that we all walk in with these preconceptions, but when we walk into a courtroom, it's up to the lawyers. It's not just the judge. It's up to the lawyers to make sure that the jury is listening. And my experience is, as the trial goes on and they see the seriousness of it, I actually think they take it very seriously.
Well,
I disagree.
And the only
they
problem,
try to do their
the only
jobs.
problem I have is in federal court, we don't get to question them.
I gotta hit a break, but when we come back, we're going to be talking about a case many of you have seen in the headlines, and it harkens back to a generation ago, that Lufthansa heist arrest. The question is the mob dead, or at least greatly diminished by the feds, and was this a lot of a dog and pony show? I see laughing from Jimmy Koutsouras. All right, we're going to be right back with that and more after this.
Business.
Yeah.